It's loud. Good afternoon, everyone. My name is Brenna Durden, and I'm serving as the special magistrate for the city of Jacksonville Beach. And this is the beginning of hearings that are scheduled for March 26th, 2025. Madam Clerk?
The purpose and function of the Jacksonville Beach Special Magistrate hearing in accordance with Florida Statutes Chapter 162 and the City of Jacksonville Beach Code of Ordinances is to reach an equitable expedition to enforce the codes. The city presents the violation and evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation and evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard.
Oh, thank you very much. Shall we begin with case number 1, Ms. Beavers?
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God? Please state your name and position.
Oh, these are new. Nikki Beavers, City of Jacksonville Beach Code Enforcement Officer.
You may proceed.
Okay. Good afternoon, Your Honor. Want to start today with case number 24262, property owner Jackie Clark, violation address 632 10th Street North, Jacksonville Beach, Florida. This is in regards to a fence that exceeds the height limitations. Let's see. Okay. All right, as you can see, where the yellow arrow is pointing down, this is a rear fence.
A rear yard fence?
Yes,
Thank you.
that appears to be approximately 8 feet in height. As you can see, it's almost touching the fascia of the roof. There is no airflow. Between 6 feet and 8 feet, it's required to have at least 25% airflow. I have sent several violation notices to the property owner, and I have not had any response back.
Okay, thank you. If it's
my front door.
it's okay. Wait just a moment.
Oh, okay.
Let me just talk to Miss Beavers to begin with. So you said this is a rear yard, and yet I'm looking at the street. So it makes it feels like the front yard or the side yard.
That's the rear. The front fence that you're seeing where the seahorse is, that's part. She's on a corner lot, so that's part of her side yard, that front fence. But where the arrow is actually pointing, that's actually in the rear of the house.
Okay, and that's based upon the definitions and the
Correct.
provisions in the code. It makes this fence. So you said where the seahorse is located.
That's not the same fence that the arrow is pointing.
I understand,
okay, yes.
But where the seahorse is that?
That's considered her side yard.
Side yard. Mm-hmm. Okay. And can you explain what the 25% airflow between 6 feet and 8 feet is?
So anything over 6 feet, there is a requirement that there has to be airflow if the fence exceeds that height.
So can you give us like an example of what that would look like?
Most people would normally either have the panels staggered or either put lattice. So, okay. And that allows that airflow.
Okay. And how did you determine that the fence, where the yellow line is?
Well, if you can look at the fence that's in the front in the side yard compared to the fence in the rear, how much higher it is above that. The fence in the rear is almost to the roof.
Well, where I'm not actually seeing that, Miss
Okay,
Beavers.
are you looking at
It
the
looks to me like
Let me see if
the
there's a.
side yard where the seahorse is located and the where the yellow is. From these photographs, it makes it look like they're the same height.
Not, let me go back. Uh-oh. I think I hit it too many times. There's a delay. Okay. As Mrs. Clark just stated, the fence that's right here in the side yard, that is 6 feet. And the one where the yellow that's almost to the fence, the one in the front, as you can see, is nowhere near breaching close to the top of the roof. The one in the rear where the arrow is pointing is almost touching the roof.
Okay, I'm just looking. Okay, I'm looking at the fence that's adjacent to the seahorse fence.
Yes. Okay. So this fence right here, this is her side yard.
Do you have a pointer?
It's not. It doesn't work on the TV. It doesn't work on the TV. Yeah, it's not working.
Okay.
So this one, the lower fence that you're looking at right here, where the seahorse is attached to it, that fence is only 6 feet.
Okay, and then the one directly to the left of it is also 6 feet.
That's all one fence, but behind it, if you look at the top of the roof, where the yellow arrow is pointing, that is the top of the actual fence.
Do you have a paper copy of the photograph that you're showing?
No, ma'am, I didn't.
Okay.
So I'm not sure if it's from your distance where you're looking at it, but it is that yellow arrow is directly on top of the rear fence.
Okay, where the point of the arrow.
Yes.
Okay. It does look like there's some kind of a wall. I can barely see between the fence, between the roof and the dark
the roof
area.
is almost
There's
sitting
a little
on top
tiny
of it.
sliver of daylight. Is that right?
Yeah, it's
okay.
The roof is almost touching the top of that fence.
Okay. So, you don't have the exact measurement because you didn't go on the property. Is that correct?
Correct.
I know.
But again,
and you're basing it on knowing that the seahorse fence is 6 feet, and it's clearly above 6 feet.
Yes, it's almost to the roof.
And it does not appear that there's any, at least in this photograph, that there's any airflow.
There isn't.
For the area between 6 and 8.
Correct.
Okay. And that is a violation of which section?
That's 34-406B4. So under B, it says any portion of said fence in excess of 6 feet in height shall be constructed in a manner which provides openings to allow the free flow of air through that portion of the fence. The openings shall be evenly distributed with the pertinent portion of the fence and shall equal not less than 25% of the aggregated surface of the portion of the fence which exceeds 6 feet in height.
Okay. The notice of hearing was sent by certified mail?
Yes, ma'am.
And did you receive a return receipt?
I don't believe so, but I did post at the property as well.
Okay, on March the 7th. That's the date of the posted letter.
Yes, I did receive a return receipt.
Okay, what is it dated?
It looks like it was, I can't read the date on here. I can't read.
And who's it signed by?
It just says Clark. It looks like it says received by Clark. And then the date may be the 14th, 3/14. Would you
Okay,
like to?
the
Can I
signature
bring it?
is Clark, you believe?
Yes,
Okay. And it looks like the March 14th.
correct.
Okay, is there anything else you want to add at this stage?
No, I have nothing else.
Okay, thank you. Is Miss Jackie Clark here? Okay, please come up and be sworn by the clerk. No, you can
Sorry,
stay there.
at the podium, and if you'll just press the button down there, it'll turn your microphone on. The button at the base of the microphone. Yep. Okay, please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address. Please state your name and address.
Jackie Clark, 632 10th Street North, Jacksonville Beach, Florida, 32250. 27 years.
Good afternoon, Miss Clark. Thank you for being here.
Yeah.
What would you like to offer?
Well, I
in way
did.
of
The first notice I got was this on my door. This is the first thing I know about it. And then I did get a certified letter later after I got this on the 7th. And the mailman rang my doorbell and told me I had a certified letter that did he want me to go ahead and sign for me? And I said, sure. He signed it, and it was the same thing that I got on the door.
And when did you get it on the door?
I got one on the door and one certified letter, and that's it.
Yeah, I'm just asking you, when do you recall when you got it on the door?
I think it was the same day it was posted.
Okay,
I could be wrong. I don't really remember.
okay,
It was in March, first week of March, somewhere there.
okay, thank you.
I do have that fence in the back, and I had no idea that it needed to have trellis because it is not really a fence that is on the line, on the survey line of the. It's in between the back fence and the front fence, so it's a middle fence in the middle. Had no idea that a middle fence had to be somewhat specified, so a height, but it is 8 feet. I don't have any problems putting the ventilation in there. I would like to suggest that since it's 25%, I'm getting ready to take the fence down in January. It won't be there after January in 2026.
This middle fence?
This middle
We'll
fence
call
will,
it the middle fence for now.
the middle fence will be gone in January of 2026. We're not going to keep it up there forever. Just it was a temporary piece that we needed. And I don't mind putting the ventilation in there, but I really want to talk about what exactly I need to do because I'm going to take those panels and use them, replace some of the older panels you see up front. They'll be cut down to the 6 feet, but I don't want to destroy the fence and putting this airflow in. So what I was suggesting is that every fourth, you said 25%, so every 4 pickets, I would cut one down to 6 feet. Is that enough?
Oh, 6 feet.
In order to get that 25% airflow.
Well, it sounds reasonable, but we would have to ask. We'll have to ask Miss Beavers and.
Sure. I mean, I'm open for suggestions without having to destroy all the pickets.
Let me ask you a couple things. You said it was only going to be temporary for
It
some
is.
reason.
Mhm.
And what is the reason that it's only temporary?
It's a temporary fix for, we needed to separate one section of the yard to the other section of the yard. That was it. It's a separation of the inside portion of the yard.
And what's going to happen in January?
Well, in January, we're going to take it down, and hopefully some of the older pieces out front you see in the picture, we're going to take those and replace it with some of the old pieces, or we'll sell it.
What's happening in January? That is there some
Oh,
project?
January
in
there won't be a
conjunction?
need. There won't be a need for us to have that.
What's your need now?
The need is a need to separate the two sections of the yard. I mean, I think that's pretty.
Okay. Could you, how soon could you remove every fourth
I could probably get that done this week.
this week?
My daughter's fiance, he's a handyman kind of guy, and so he said he would definitely come over and take care of that for me.
Okay. We can have a little bit of a conversation back and forth. Miss Beavers, um, it sounds to me like Miss Clark would every fourth panel or picket. I guess that's a proper word. Picket. Would that equate to the 25% airflow under this particular section of? It says equal, not less. It shall be evenly distributed. The opening shall be evenly distributed with the pertinent portion of the fence and shall equal not less than 25% of the aggregate surface area of the portion of the fence which exceeds 6 feet in height.
Correct. As you can see in the pictures, I can only see that corner of the fence. So if Ms. Clark will allow me access to see the rear part, the remaining, and see how far across. I know you said that it goes across, it's just in the middle.
Can you
No, it's
speak?
just that corner.
Please speak.
It's just
It's just really
Speak into
Okay.
the mic.
Then I believe that should be sufficient. Christian is with the Planning and Zoning Department, and let's see,
Okay.
was there anything?
If Christian would like to speak first,
Manner with planning and development. I haven't heard of this interpretation before. It does say that any portion of said fence that exceeds 6 feet in height shall be constructed in a manner. So I would say if it equals 25%, that would be fine.
okay. And you said that you could accomplish this. This is the 26th, let's say, by April 10th.
Yeah, April.
Would that be
10th
fair?
Fine. That'd be fair.
Okay. And then would you also agree that you've said that you would take the fence down? I don't think that's absolutely necessary if it's in compliance.
Well, eventually it's going to. I mean,
Okay.
I know the dead days, so that's what's happening. It's not going to be there for any length of time, so it's not something that's going to be. I mean, we've already set that in stone. We already know that that's what's going to happen.
Okay.
25th.
And
So-
the other thing that Miss Beavers mentioned was that she would like you to let her view the fence.
I would
Once
like to
it's
send you some
once it's-
pictures. I have my pets, and my pets are the most important thing in my life to me. So I prefer that I would send you pictures versus coming on site.
I have to verify compliance, so I would need to actually come onto the property to verify that it's been.
And
in
the other
compliance.
option is we cut it down to 6 feet,
Yes.
or can we put holes in them without having you to come on? I don't.
Is there,
know
other than are you able to put your pets?
I am, but
It's
I
like
don't wish.
a 5 minute.
I don't really wish to do that, but you could if you wanted to. It's
Okay,
not that big a
yeah.
deal, but I'm not happy about that. I don't know why she would have to come to my house and come on site. She can't go out and look at the neighbor's yard off site, so I can't imagine why she would want to come on my site and look on there.
What do you mean by the neighbors?
The guy across the street, he has a trailer in his parked his front yard and doesn't even have a tag on it, but you guys can't been told you guys can't get out of the car to look at that.
That's separate from this
I
case,
get that.
but he has been cited for everything, and he's in compliance with everything that you
Okay.
complained about.
Well, that would
on
be
his
nice.
property.
The thing about that would be nice if they told us that.
Okay, we're off
Yeah.
topic. So I would like to, it sounds to me like there's an agreement.
Yeah, so if she can, Ms. Clark can just contact me. That way I can just come. It'll be just a 5 minute inspection to verify that the fence is in compliance.
Okay, no problem. It'll have to be after the 10th. I'll be out of town till then.
Okay.
Okay.
I'll have to contact you after that because I won't get back till the 10th, but it could be the 11th. So I'm out of the town from the 6th through the 10th.
Okay, so I think you said that your son-in-law could get it done.
Yeah, he's here. I
Okay.
won't be here.
Okay.
So does if I was going to put in the order that you would remove the every fourth picket no later than April 10th. Is
Okay.
that acceptable?
Sounds good to me.
Okay, and then you'll contact Miss Beavers, and I'll put her email address in the order for you.
Okay.
Um,
I just want to be home when you do come on site.
I'll put in
That's your requirement.
the address and the phone number for you,
Okay.
and
Perfect.
then
If Miss Clark can leave her phone number when you get ready to leave, if you can stop by the planning and zoning department at the end, right across from Beaches Energy, and just let the clerk know that you're leaving your contact information. That way, I can contact you after the 10th.
Oh, you can write it
Okay.
down now.
Oh,
And
no, I
then
didn't know if you wanted
the-
to give your number.
It's 904
Mm-hmm.
226 7099.
and then the last thing that is standard.
7099.
7.
099.
Okay, thanks.
The other thing that's standard in these orders, Ms. Clark, is that if you don't come into compliance as you've agreed, then there would be, it would come back to me and have the potential for $250 per day violation. So that's why I wanted to make sure that you're okay with the April 10th
Okay.
date.
No problem.
Okay, great. Then I've announced my order, and that concludes this matter unless you have anything else, either one.
I don't have anything else with this case.
Okay.
All right.
Okay, thank you very much for being here, Ms.
You're
Clark.
welcome.
Okay, thanks.
You still need me to stop or no?
No, I
Okay.
just need your contact. Thank you. Okay, Your Honor, moving on to case number 25303. This is RHC Associates, Duncan Brands. This is at 1325 Beach Boulevard, Jacksonville Beach. This thing has a delay. Okay, there we go. It's in regards to a non-conforming sign. It appears that the sign was damaged during one of the recent storms and has not.
Can you be any more specific on that?
Okay, let me go to the picture. As you can see, the Duncan sign that was in the middle is now missing. So the sign is considered a non-conforming sign.
What
And
makes it non-conforming?
because it's a pole sign.
It's a pole sign, and pole
Yes.
signs are no longer authorized in the
Correct.
in your code. Is that right?
Yes. So once the signs have been damaged, they would have to replace them with monument signs.
And when do you think it was damaged?
This case was started.
What's the date? While you're looking up that, what is the date on the photograph?
This is January 6, 2025, and that is the date of the original case.
Okay. What is still, what part of the sign is still in existence?
This is what's left of it. The part that's the opening at the top, it originally was a Dunkin' Donuts sign up there, and now that's
Is the
gone.
Dunkin' Donut still there?
Yes, ma'am. And let me go to. So here is. This picture was taken today. This is the actual structure and the sign.
What's it say on the sign right now?
Dunkin's $6 meal deal. $6 meal deal.
Okay, tell us about the provisions in the code that talk about the
Christian.
the state of the.
Okay. Christian.
this.
I'll give you kind of a summary and then I'll point out the
Okay.
specifics.
Could you announce your name?
Sorry,
for the
Christian
record?
Popoli, Senior
Thank you.
Planner. In essence, going back at least to 2015, I believe back to 2011, the city determined that pole signs weren't acceptable any longer. So any existing pole sign was deemed a legal non-conforming sign at that time. The code has several provisions under which those signs have to be removed. The previous code under which this was cited basically said if it was not used for more than 60 days, or if it was damaged and deemed unsafe, or if it needed some kind of structural repair.
So there's three ways for it to become.
Right. There's also some leeway to the building official as well when it comes to the question of safety. But in essence, if a sign is damaged beyond 50%, or you would have to make structural improvements to maintain the sign, in this case, the entire upper portion of the sign is gone.
And where are those provisions again?
So this starts on
Section 34.
450?
450, yeah. And there's under, what is that? Under E, 2, 3, 4, and 5. Specifically, number 2, letter B, a nonconforming sign shall not be re-erected, relocated, or replaced unless it is brought into compliance with the requirements of this division, which would be a monument sign. And then nonconforming signs shall be removed or rebuilt in full conformity with this division if it is damaged or allowed to be deteriorated to such an extent that the cost of repair or restoration exceeds 50% or more of the cost of the replacement sign. New and additional signs for nonconforming uses shall not be permitted. A nonconforming sign, that's for you, sorry. Signs which remain vacant, unoccupied, or devoid of any message or display pertaining to a time, event, or purpose that no longer applies for a period of 180 days shall be deemed discontinued. And then so if the building official determines that the sign is unsafe or in unsafe condition, he may immediately notify in writing the owner, who shall correct the condition within 48 hours. The correction basically would be to remove it if it was damaged to the point of being unsafe.
So has the city determined that the sign is unsafe?
No, it's just damaged.
Damaged. And which one is that damaged?
This would be under number 2, letter C.
C. If it's damaged or allowed to deteriorate to such an extent that the cost of repair or restoration is 50% or more of the cost of replacement of such sign. Have you determined that it's more than 50%?
Yes, because the entire sign that was in the center is completely gone.
Additionally, under letter B, it says it shall not be re-erected, relocated, or replaced unless it's brought into compliance.
Yeah, I'm just trying to get to the point where it's supposed to be removed or rebuilt in conformity with the terms of the division if it's damaged or allowed to deteriorate. That the cost of repair or restoration. So do you have a determination on the cost?
No, we do not have that. But when I did speak to the previous owner, the business is actually going through a ownership change.
The franchise for Dunkin' Donuts.
Correct.
Is that a Dunkin' Donuts right now?
Yes, it is a Dunkin'
Okay.
Donuts. So the sale of the business probably won't continue or won't be complete within the next 30 days.
The sale of the franchise to the new
transaction
franchise.
between, yes. So it's a situation between, is the previous owner going to be responsible for it or the new owner? And I've spoken with both.
So who is RHC Associates? Is that the current
That's the current owner.
Okay. And that's who you provided notice to?
Yes.
Of course they are the current owner.
Correct.
Are they the owner of the property or the operator? Or
they're the
operator
owner
of the business or both?
Both.
Okay. So, let me step. I still have the question about C regarding the cost to restore, or the cost of replacement for the sign. Are there any other bases out of the code for
Yeah,
determining?
there are minimum maintenance standards for signs, but under number 1 in that section, letter C, it says a legal non-conforming sign may not be altered in any manner not in conformance with this division. It doesn't apply to reasonable repair and maintenance or change of copy of that sign. By change of copy, structural alterations are not required. And then any building permit for any addition, alteration, or improvement valued at more than 50% of the market value of the structure or the building for which locations. I'm sorry, that's really not. That's overly complex. I'm not even sure what that is referring to. So basically, it cannot be increased in height. It cannot be repaired to the extent that it's not in conformity. So, in essence, they wouldn't be able to put the top portion back regardless. And then there is a provision. So it says that removal of discontinued non-conforming sign shall include all sign supports, components, angle iron poles.
What section? I'm sorry.
That is 34,450, number 4, discontinued signs, and then letter D.
Okay, so in that instance, for the signs discontinued, it has to be for a period of 180 days. Can you, Ms. Beavers, do you know when the damage to the sign occurred?
I don't recall when the damage actually occurred, but it was actually cited January 6th.
So that's less than 180 days.
Correct.
So are you saying that it was cited 180 days, not cited, but became damaged, or actually, what's the word?
It was
Vacant,
damaged before
unoccupied,
January.
or devoid? 180 days before January the 6th?
I'm sorry, say that again. You saying was it damaged 180 days prior to January 6th? Based on the storms that we had, I think our last storm was probably in September or October of 2024. So from that date up until the date that it was cited, or up until now, would exceed the 180 days.
And Magistrate, if this helps any, there's no way for them to basically replace what was there without requiring a permit and potentially structural elements because the sign is literally broken off. So they might be able to continue using the existing lower portion, but they can't replace it at the top because then it would not be in conformity with the code. So any additions or alterations to the point that it would basically require a building permit, which this would because it's a new electrical cabinet that would go in, they wouldn't be able to do that. So they could potentially, depending on the timing, keep the lower portion, but at least our opinion would be that if they did so, they would still have to remove the portion above that's not part of the sign any longer because they can't put any advertisement above the changeable message sign portion.
Okay, so we know, based upon this, it seems to me that as of January 6th, when you cited them, the 180 days would have already have been in play, would have had to occur if you are going for a violation under subsection D. If you're going for a violation under the section that talked about it, the value, hold on, let me find it.
That's under C, 2C.
Yes, thank you. 2C, then it would seem to me that you need to know the value. The cost of the repair or restoration is 50% or more of the cost of replacement. Otherwise, you don't trigger that. You've got to know that information to be able to say that under C, the sign is no longer authorized.
Magistrate, not that this is, 100% our evidence, but just looking at Google Street View, they have listed it over 10 months ago, showing the sign missing the top portion.
And I'm sorry, where?
This is in just Google Street View, so the cars that drive around and take pictures of everything. They have various dates where they post the changes, and the most recent one on Beach Boulevard was more than 10 months ago, and
When
it shows
was
the
that?
sign.
What's the date of that photo?
Let me find the specifics. May 2024.
So right now, that's not in evidence. Is there a way
We could
for
certainly
us
produce
to?
a hard copy if you'd like. I can go do that.
I think that would be the minimum necessary.
Okay.
Is someone here from RHC Associates? Okay. Okay, one moment, please.
He's just gonna go print out.
He's going to go get this photo,
Okay. Sorry.
which wasn't part of the notice that you received, but we'll see what's going on. So we'll wait for him to return.
Okay.
Well, do you want to be? You can be sworn in now.
Okay.
We'll save time.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Walter Amaral, 601 First Street South, Jacks Beach, 32250.
And could you repeat your last name, please?
Amaral, Amaral.
Thank you very much, Mr. Amaral. We'll wait for him to come.
Okay.
Your Honor, I do have a question. Being that we don't know the exact date of when this sign was constructed, so in regards to the 50% that need to know the actual value of it, how would we measure that based on the length of time that the sign has been there compared to the cost of it? Mr. Amaral, is it Amaral?
Mhm.
Have you priced what the cost of the repair would be when it was initially damaged?
I was getting pricing, but no, I did not actually get a figure. I reached out to several.
Could
but
you
they
speak
never-
into the mic, please? Thank you.
I've reached out to several vendors, but they didn't get back to me.
To ascertain the cost to repair.
Yes, and then one of the vendors told me I couldn't repair it anyway. I would have to reduce it to a monument.
Oh, he was okay. So you don't have any idea about the cost to repair.
No.
And so, based off of what,
Could we wait
Okay.
until the photo comes?
okay.
Please. Did you give one to Mr. Emerald?
Uh-oh. Oh, no, we're putting it. Okay, got it.
Uh-oh,
Okay,
I don't
it's on
think
the
that
other
does
side.
it.
Flip over.
Oh, it's
Okay.
double-sided.
So based on what Mr. Emerald just stated
Oh,
that,
well, I have some questions.
okay,
So what was the date of this photograph,
three,
Christian?
okay.
It says May 2024. It doesn't give an exact date.
Okay. Mr. Emerald, do you recall when the sign was damaged?
It was one of the storms, so I don't remember. I don't remember exactly. It was the last storm.
So Christian's provided us a sign he believes based on Google date that it was May of 2024. Do you believe that this is what the sign looked like in May
Oh,
of
absolutely.
2024?
Yeah, I'm not debating that. It's
What,
definitely been 180 days.
excuse me, for clarity, yeah, you think that the sign did look like this in May of 24?
Yes.
Okay. Okay, and in May, it's showing that it's Duncan, and that's your business. Were you operating the business at the time?
Yes, ma'am.
Are you still operating the
Yes,
business?
ma'am.
Okay. And so today's sign, you said this is the sign today.
Yes, ma'am.
That has something to do with Duncan, right?
Yes,
The
ma'am.
message on the board. So I'm going to ask the city, the provision that talks about the 180 days says that the sign has to remain vacant, unoccupied, or devoid of any message, or display that or display a message pertaining to something that no longer applies. So at least this portion of the sign in, appears to me to still have a message, both back in May of 24 and as of now, that is, so the sign's not devoid of a message, or vacant or unoccupied.
Correct, but there was another portion that was up there, and as what I was stating, Mr. Emerald even stated as well that when he contacted some of the vendors, one of them even told him that it's not repairable, that he would have to change it to a monument sign.
Well, okay, Mr. Emerald, do you know why he told you that? Did he tell you that because of the code, or did he tell you that there was a structural problem with the sign, that it
No,
could not be?
he said it would probably be a code violation.
So do you have any idea whether anybody's told you you can't restore the sign because of a structural problem?
No. No, it's as far as I can tell, there's nothing wrong with the structure.
Okay, so I have some concerns about finding that the sign has been, quote, discontinued under subparagraph 4 because of the provisions. The other section that we talked about was the cost to, it would be 50% of the two that's under 2C, that something that would render the sign non-conforming. If it's damaged or allowed to deteriorate to such an extent that the cost of repair or restoration is 50% or more of the cost of replacement of the sign. So I think that I would have to have evidence of that, so that in order to rule that the sign has been rendered non-conforming.
Okay.
If I may, the sign is non-conforming by its nature of being a pole sign. That is a prohibited type of sign. And under number 2, letter B, it says a non-conforming sign shall not be re-erected, relocated, or replaced unless it is brought into compliance. So I think, at least from our standpoint, I think the argument could be made to keep the changeable message portion as far as it's existing, but as far as replacing anything above that, my opinion is it would violate letter B.
But your testimony earlier stated that the sign was a legal non-conforming sign
Correct.
and it's your position until it was damaged.
It's a legal non-conforming sign, but it is still a non-conforming sign. And once a non-conforming sign is damaged, it can't be replaced or repaired
Right, but
or re-erected.
but the way to get to the damage or to the 180 days discontinued, there has to be something that triggers it changing status from legal non-conforming to, quote, illegal non-conforming.
That would be when the sign was damaged to the point that it's no longer there. And since it is gone, it can't be put back, regardless of the time or money. It's just a function of letter B says it cannot be re-erected, relocated, or replaced unless it comes in compliance with the code, which in this case would be a monument sign.
So how high could the monument sign be?
It's a long sign code. So it can be a maximum of 10 feet high and 12 feet wide.
So how high is the sign? You've mentioned that he could, the city would accept the idea of keeping the sign that's there today. How high is that? Is that
It's about 15.
I'm not sure, honestly, but keep in mind that the compliance of the monument sign would also include the enclosure of the bottom portion. Otherwise, it is a pole sign by nature.
it's a what?
A pole sign, by nature, if it doesn't have a completely enclosed skirt that goes all the way to the ground.
So he would have to, in order to come, you're saying that in fact he couldn't keep the sign the way it is if he cut off the two poles above the sign.
That's possibly something I would need to discuss with the director. That's a very on the edge of interpretation. Regardless, I think that the upper portion should be removed, but whether they would have to enclose the bottom and whether that's over 12 feet, I can't say.
Mr. Amaral, do you have a concern if I were to continue this hearing to the next special magistrate date? There's a few things that I'd like you to, you and the city to work together to determine if you can come to an agreement. I have some concerns. I haven't heard evidence today that is enough to find that you're out of compliance and that your sign is turned into an illegal non-conforming sign at this point.
Can I just add two things?
Yes.
First of all, my hope was to, what you said about, the lettering being there and all that, making that a useful sign. I was going to bring that up, and I'm glad you did. And then the gentleman suggested cutting off the tops. I'd be happy to do that and leave the sign the way it is. It's right now. It's a temporary sign, as is right now, because he's going to tear it down. When he takes over the site, the whole sign is coming down either way. So this would be a temporary fix, and
Okay, I'd like to hear from the other gentleman now. Don't go too far.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Please state your name and your address.
Kevin Patel. My location will be 116
Okay, speak a little bit louder.
116. So Kevin Patel, 11657 Beach Boulevard, Jacksonville.
Okay. So, Mr. Patel,
Yes, ma'am.
could you tell us when you expect that the new sign, your new sign, well, first, just for the record, is it correct that you plan to become the new franchisee?
Yes. So I will explain. I'm not sure if I spoke to her or somebody from the city.
It's okay. This is the record, so you
Okay,
can tell me.
so the whole process, I'm gonna kind of narrate here what the process is like. So we haven't gotten to agreement yet. There's still being drafted. Once we draft that agreement, we come to an agreement that this is what the final draft is to look like. Then we sign it, we send it off to the brand. Then brand takes about 60 days from that point to whether to make that decision, whether obviously I'm an existing franchisee, but then they need to look at, our records and whether we're correct, perfectly fit for the site or not. Once they approve it, then we pick a closing date, which happens about 30 days after approving the 60 days. So already 90 days there. Like he said, if you were to remove the structure the way it is right now, it's called pylon sign.
It's what?
Pylon sign, which pole sign. And now the city is calling it to be monument sign to come back into compliance. Well, for that, it's a whole process. We have to do the engineering work, drawing, set it off to the city to get permit pulled. Once that permit gets pulled, then our vendor guys actually start working on this sign. Anything with about manufacturing and delivering takes minimum 10 weeks to the site.
Okay. Right.
And obviously, after that, they're able to work on this site. Now, time frame wise, we're not sure exactly how long it's going to take.
Okay.
But I do. Go ahead.
So, right now, though, the two of you, Mr. Amaral and you, have not come to an agreement for the transfer of his interests over to you. Is that correct?
That is correct.
Okay. And how long have you been working on it so far?
We've been working for about a month and a half, or close to 2 months.
Okay.
It's been drafting process.
I understand it takes a long time.
Yes.
Let's assume, and it's a big assumption, but let's assume that you and Mr. Amaral did come to an agreement. Would you expect to be operating by January 1st of 26?
Yes.
That's about 9 months, 8 or 9 months. Is that reasonable, or is a year a better?
It is reasonable. The only thing that I had mentioned, which I haven't, so what the brand is looking for right now, so it's called non-drive-through location. So what the brand is actually suggesting, going over from non-drive-through to DTO, drive-through only concept, which talking about tearing down the entire building altogether. So that's where, and we haven't heard from him on his side. We don't know exactly what the process is going to be like from the brand side alone.
Okay.
So there are a lot of parties involved. And I think at the end, like I had told her, we would love to be in compliance because that's where, we're here for that. And we would like to have sign there because technically he's losing business right now without having sign up there.
Okay. Well, that's very helpful, and I don't have any any further questions for you. Thank you. Where, just to be very, transparent, where I was headed was I thought that if there was some certainty about that, maybe we could find a resolution based upon the eventual removal. But it's a little too uncertain for me to rule based on that.
So the city recommendation would be to give them time to get this transaction at least in motion to come back in 90 days?
Come back in 90 days.
Yes.
Let me ask Mr. Emerald. The city's recommendation, I think, based upon what they've heard today, is to continue the hearing. There won't be any fine issued or put in the documents at this time. I won't rule on the matter. I will issue an order that basically says that we will come back in 90 days.
Okay.
At that time, I would expect that, perhaps you and Mr. Patel will be further along. There may be some more certainty between the two of you. And it's possible that the city will have some more information in regards to the things that I pointed out regarding the cost to restore, or alternatively, the evidence about the number of days. So I think if sounds like that's is that acceptable to you, Mr. Emerald?
Yes, ma'am.
Okay, then we'll see you back here in 90 days.
Okay.
That'll be our June 25th hearing.
June 25th?
Yes.
Will you be here, Mr. Emerald? I always check because of vacations.
Yes.
Okay, and Mr. Patel, can you be there? Can you be here that day? Or at least provide a sworn statement. June 25th. Okay. Then this matter will be continued to June the 25th. And we'll take it up
We'll
again
do a
at that time.
follow-up and see where they are in the process at that time.
Okay, thank you. Thank you very much for being here, both of you.
Thank you.
All right. Okay, Your Honor, moving along to item C on the agenda, case number 24281. This is Parish Rentals LLC, violation address 725 North 3rd Street, Jacksonville Beach, Florida. This is a case of a non-conforming sign. In regards to the sign, the business has been closed more than 180 days. So that would apply to the violation of this current sign.
What was the business?
It was Seahorse Florist.
Do you know when could you tell me the dates that you're using for the 180 days?
I don't have the specific date, but I've only been working here 4 years, and the sign it hasn't been a florist shop since I've worked here, which is over 4 years.
And it was cited back October 2024. Yeah, the business has been closed.
And that was, Christian, you testified that it's been closed as long as you've been working here?
Correct.
And that's more than 4 years?
Yes.
And so does this, I gather that you believe this sign constitutes a pole sign?
Correct.
Okay. And I see that it posted and sent by certified mail.
Yes. This was on March 6th, and as of today, the property still remains in violation.
Okay. What's your recommendation on this one?
My recommendation would be to issue a $250 per day fine until the sign comes into compliance.
And how would it come into compliance?
By removal.
Okay.
Magistrate, if I may, the other aspect of this that I don't think we necessarily referenced, but the property has changed from commercial to residential. So it's no longer a commercial property, in which case residential uses have a very different amount of signage that they're allowed to have. So this doesn't even if it were still legal, it's not a commercial entity.
Great. Okay, so that's commercial. Both the use and the zoning used to be commercial, and now the use and
The zoning is still commercial, but it's been converted to multifamily.
Okay, so it's still zoned commercial, but it's converted, and that's apparently a lawful conversion to
Yes.
residential.
It's underway. They still have outstanding permits.
Okay. Is there anyone here from Parish Rentals LLC?
Hey, how are you?
I'm good. Nice to see you.
Nice to see you.
Please,
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Brent Parrish, 725 3rd Street North, Jacksonville Beach, Florida, 32225. I'm sorry, 32250.
are you the landowner,
I'm one of them.
or
Yes, ma'am.
you're one of the managers of the LLC?
Yes, ma'am.
Okay. Do you have any concerns with the recommendation to remove the sign?
I'm pretty amenable to it. I don't really have many concerns about it. We were hoping to possibly save it, if possible. It was just a discussion that we had with zoning, but we just haven't gotten to the point where we could have that discussion from the business side.
What would you use it for business if you have a residential now?
We would just use it as kind of a monument. It's more of a nostalgic thing. I had several people come up to the building and say that they remember the sign with a little clock on it. It was nothing really significant, to be honest with you.
How many days would you say are necessary for you to be able to remove it?
I can't really answer that at the moment because the other business partner is very difficult to make decisions with. And so the financial obligation to do so, I haven't really gotten any written quotes because it's very difficult to deal with a lot of sign companies. But it's not cheap, I would propose.
So it's clear to me that, I mean, based on the testimony, the florist hasn't been operating there for 4+ years.
I'm not sure, to be honest with you. I mean, I'm not sure what the operating of a business would mean if they're selling flowers out of it, if their business is active and it's actually sitting there. I wasn't a part of that business. So I can tell you that as we purchased the building December or January of 2025. So.
Okay. I'm going to rule that the sign does need to be removed, based upon the fact that it's still advertising sunshine. No,
Seahorse.
Excuse me. Seahorse florist. Testimony is that florist hasn't been in operation for more than 4 years.
Okay.
But I'm going to give you an extended period of time to complete the removal. I think that I think a reasonable time might be 90 days. Would that be reasonable in your mind?
It's very difficult for me to say.
Well, what do you think would be?
Possibly 180 days. I don't want to, give too much of personal information, but it's just we're dealing with a lot of different situations, and the idea behind it, the financial burden is going to just cost to remove it. It's
Okay, let me ask the city. So I threw out 90, you threw out 180. I'm going to ask the city if they have a recommendation.
I do have a question. Your active permit right now, do you know when that permit will expire?
off the top of my head, I don't. And that was kind of the other thing is it hasn't actually converted. We keep getting these messages that we're no longer commercial. Technically, I was assuming, and the reason why I haven't acted on anything actually is that an email I received from Christian stated that, we need to, we have converted to residential. My interpretation is that the building permit needs to be closed out, basically certificate of occupancy, which would then convert it. And that's why I really haven't acted on it at this moment, is because I assume that as it sits, technically it's still the same use. Is that not correct?
Do you have a building permit for residential? Is that what?
There's an all-encompassing, and I might be wording it wrong, but essentially the building permit was for renovations of the building.
To convert it into
to convert it into an
residential
occupancy
unit?
change.
And you got that permit?
I do. It's currently active. Yeah.
And how far along are you at the point to ask for certificate of occupancy now?
I'm pretty close. Again,
So you've invested the money to
Oh, yeah.
making it residential.
yes, absolutely.
Okay. So I apologize, Nikki. What was it that you were?
So initially, I was asking when did the permit expire, and I'll find that information out. But also, being that it was under commercial, under section 34-450 for non-conforming signs, under section under 4, under signs discontinued, the building has been vacant for a number of years, so it would also fall up under that.
Right. I would agree.
Yes.
So,
The building wasn't vacant.
The business has not,
I mean, we can.
Seahorse Floors has not been in business for,
right.
Christian has been here 4 years, I've been here almost 7.
Magistrate, I think what the applicant's probably going to say is that there are residential spaces that were there previously that were occupied, but the use as a commercial property with commercial advertisement has been ceased for a very long time.
Right. Right. This is different from the one that you heard before. Clearly, the business has been gone. It's advertising a business that's been gone for 4+ years. Given that it's deemed to be discontinued. And once it's deemed to be discontinued, then it becomes an illegal non-conforming sign, and removal is the requirement of the city code. So I'm back to my original question, which was, what is a reasonable I'm trying to be reasonable about the removal, the requirement, the time frame.
I'm gonna have to get with. 180 days is about the longest I feel even comfortable asking, but I can't.
The city is going to recommend 60 days because the business has
How many?
60 days.
60. Well, I think that's a little short, and only because it does take time to get estimates and then get the the finances together. I would say that, the city had lots of chances previously. The business has been out of business for 4 years.
And we cited it originally back in October of 2024. So
So why am I only hearing it for
They
the first
sent,
time?
I don't know where they sent any of this mail. I never received it. Christian was actually kind enough to send me the letter in December
Well,
via email.
the address that we have on file is 13245 Atlantic Boulevard, number 2124, Jacksonville, Florida, 32225.
Did you own it in a different capacity, a
No.
different entity before in October?
No, as a matter of fact, I walked in and George Knight actually kind of made a joke. Not a joke, but he was just kind of like, hey, did you get that letter about that sign? I didn't know what he was talking about at the time, which prompted me to contact Christian and ask him, about, or actually, I think it was Callie. And she had somehow I got an email from Christian. I think it was just trying to figure out what it was all about.
Who, Nikki, who did you send in October? Who did you send the notice to?
Your Honor, I don't have a copy of the violation notices with me, but I do have them in the office.
Okay. Well, we're only working from the one that is dated March the 5th. So that was the posted one, and then there was another one, certified mail,
Hold
March
on
the
1
5th.
second, because we do have, or was it the most recent one? Okay. Christian is searching. I did send him a copy of the violation notice. Not sure if it was all of them from October.
This is the one from October. It was from October. It was to Parish Rentals LLC at 13245 Atlantic Boulevard, number 2124, Jacksonville, Florida, 32225.
Is it still owned by Parish Rentals LLC?
Yes, ma'am.
Did you buy the company?
No, we purchased the Seahorse. We purchased the building from the owners of Seahorse Florist, and we started a new LLC, and we basically started renovating it. We applied for the building permit as well. I don't know how this didn't all come up when we were dealing with it because they seemed pretty thorough when we were doing the building permit application.
I'm going to rule that I'll give you 120 days to get the sign taken down. Just trying to find a happy medium between the two, and in particular, there's no doubt that that the sign is constitutes an illegal non-conforming use at this point, and therefore, I'll rule, but I'll give you 120 days, which will take us out to sometime in July. After that date, the $250 per day will be triggered. If it's not repaired by then, the matter will come back to me, and I will trigger that $250 fine. So I hope that you can manage to get it down in 120 days.
Thank you.
Thank you.
May I ask a quick question, Christian?
Probably.
Of course.
A monument
You
sign
want
is
the-
allowed.
on the record, or you want to?
It doesn't matter. It's so hard to kind of get together. I just wanted to know if there was a way to modify the sign to become a monument sign similar to what we were talking about earlier with the Duncan. I'm not trying to compare the two. I'm just saying if she wanted to do a monument sign, would that be an option here?
No, because it's not a commercial property and not a commercial use.
So
You have access to free speech signs of a certain size, but basically you can't have a full-sized sign.
Nikki, could you or someone tell me what the date in July? And when I say 120, I'm looking for the date of the hearing.
I believe it's going to be the July hearing. No, or is that August?
Is it the fourth Wednesday?
Yes.
Yeah, it'd be the 30th, July 30th.
That's the July hearing, July 30th. Okay.
July 30th?
Yes.
Okay.
Oh wait, you said it's the 4th?
The fourth Wednesday.
Oh, it's the 23rd. I'm sorry.
The 23rd, July 23rd.
Okay. That'll be the date.
So, Your Honor, just to be clear, the sign needs to be in compliance by the July 23rd date.
The sign needs to be removed by July
Removed.
23rd.
Right. And the $250 per day fine would be determined once we came back July 23rd. Okay.
Can I get a, just, I think she's on the track of what I'm not quite understanding. So July 23rd, starting July 24th would be $250 a day, or it's 20 days from today?
So when we come back on July 23rd, if the sign has not been removed, then the special magistrate will then order
Okay.
a fine.
I just have to be very thorough in my
Yeah,
explanation.
that's why I was asking the same
Yeah.
thing.
If it's down by July 23rd, there won't be any fine.
It'll be a fun. I've had several people say, "Why don't you just take a sawzall and cut it down?" Which seems pretty crazy.
Okay.
Thank you very much for being
Thank you,
here.
Mr. Durden. Thank you. I appreciate it.
Uh-huh. All right, Your Honor, going to item D. At item D, case number 24267, property owner Desluna LLC, violation address 223 South 9th Avenue, Jacksonville Beach, Florida. This is also a non-conforming sign. This sign has been abandoned for more than 180 days. This property was originally cited October 3rd, 2024. The sign was damaged. It's hard for you to kind of notice, but the sign is leaning on this picture when it was originally cited. On the next one, this is where you see the sign has been secured or stabilized by the yellow beams that are have been attached to it.
What's the date of that?
The October 29th.
Okay, thank you.
This property has been closed for a minimum 2 years.
When you say it's been closed, you mean there's been no
Vacant.
operation?
No operation. So when I reached out to the property owner back on the October 3rd in regards to the sign falling down, October 29th is when we noticed the repairs that had been done to it.
Did you issue a notice in October?
Yes, ma'am.
And what did it say?
For some reason, I did not bring none of my violation notices with me today. Christian, was that one that I sent you?
I don't think so.
Okay. But it was in regards to the sign being damaged and a non-conforming sign.
Through the magistrate,
October 3rd.
the sign actually, that first picture shows it leaning. It was almost completely over before the repair started. I happened to drive by it pretty much every day.
Yeah,
This was
after a
probably
storm.
Hurricane Milton.
It was during the storm.
Okay, and what is your recommendation for this sign?
My recommendation would be for the sign to be removed. 30 days.
And that is based on the fact that there's been no operation for any business for over 2 years.
Correct.
Also, the sign was damaged to
Yeah.
the point of should have been removed. The building official probably should have forced them to at that point, but
Right. But the damage requires that 50%.
well, or if it's unsafe,
Value.
then it was
It was
falling over,
unsafe. It was.
and it could have potentially
yeah.
fallen into the street. It literally, like the bottom had rusted out and it had folded. I just don't think we got a picture between then and when it was repaired because they went in and fixed it rather quickly.
Yeah, each day from the day that this was taken, it was leaning more and more and more.
Okay. Is there anyone here from Desluna LLC?
Good afternoon, Your Honor.
Hi.
Hi.
We'll need you to be sworn in and state your names for the record, please.
No problem.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name and address.
Despina Malios, I can spell that if needed. D as in David, E, S as in Sam, P, I, N as in Nancy, A. Last name Malios, M as in Mary, A, L-L-I-O, S as in Sam.
Mallio
S as in Sam.
Malios.
Yes.
Is that right?
Is it possible for my father to also swear in as well?
Yes,
Yes.
please.
If you could step up to the mic. Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Adonis Malius, 2822 Broward Road, Jacksonville, Florida, 32218.
Thank you for being here.
Thank you.
Could you tell us about your, if you're in agreement with the recommendation of the city?
We're not in agreement. We do want to start off with the initial notice that was received on October 3rd did not state anything regarding non-conforming or that it needed to be removed. Precisely, it said that the sign was declared that it needed to be repaired.
May I assist, Your Honor? May I assist?
Just for clarity,
Yes.
it said it needs to be repaired and
Nothing else.
Correct.
So,
okay. And Mr.
May I-
Malios, you want to say?
I would move, Your Honor, for this violation to be dismissed on the basis that there is no. We have complied with everything that was asked from the officer, and the building is currently constantly. We're marketing the building to prospective tenants. It is vital for our marketing to have the sign there. The sign is totally secure. It was never a threat to anything until we, of course, we repaired it immediately. And it is not true that the sign was leaning day by day, because when we put it back in place, it was the same effort of the hurricane to push it back in place than for it to come down, because it would have come down very easily. But the sign was in a very good structural condition, and I'm a mechanical engineer, and I can attest to that. Also, it is highly prejudicial for our business if we lose the sign, because it's been grandfathered. We're actively making efforts, and we have meetings on a weekly basis, basically. We do have a problem with the Jack's Beach homelessness and vandalism and everything that we have not been able to get help from the city. And the officer who's back there, I've met him in place, chasing away homeless and trying to secure the building. And they did manage to break in at times, and we have signed up for the police to have access and any help we can get from the building department to bring this beautiful property back into business will be appreciated. But as far as this case, I moved to be dismissed because it wasn't, nothing was mentioned about non-compliance in the order, and we did move immediately to secure the sign. It wasn't by no means 50% of the cost of the sign to secure it, and I've requested the officer by email. I've notified the officer by email and by phone to have a meeting and avoid litigation, so to speak. And I haven't received any responses from the city, which I understand they're busy. And
When did you do that?
I did that in October. I did that
Yeah.
in last few weeks ago when we received the last um, violation or notice of hearing, and we've been on top of the business.
Was there any communication in October after you got the October 3rd notice?
Yes, there is an email stating that
The communication was a voicemail to the officer that we completed the work, but we never received a response or anything.
Is it completed?
yes, it
The
is.
structural.
It,
Yes.
it was completed and it is.
Could you show us some other signs? I mean, photographs?
This is the completion. Like, as again, the business has been closed,
So is that the completion? Is that
and so for the property owner to state that they were able to re-erect the sign, and they have
It wasn't there.
as you can see, there's things stabilizing, holding it up all around it. So that goes to show you that the sign was not stable because they put the three poles that's coming, extending from the out on each side of it to keep it erected.
May I see the October 3rd letter, please? Not the photo, I want to see the letter that was
Okay.
sent.
Oh yeah. I don't have the letters with me. I didn't bring. I don't know
Okay.
why. I think I.
Do you have the letter, Mr. Melios?
I do, Your Honor.
Would
In
you show
each-
it to Ms.
Yeah.
Beavers and just confirm that it's the one?
We didn't bring this officially. I don't know if that matters. Like we didn't officially
I
And
just-
they got several other notices after October 3rd as well.
Okay. I guess we can show this.
Okay.
We just didn't submit this to the court or anything, so I don't know if that makes a difference.
You reference in this March 5th notice of hearing an October 3rd
Yes.
letter.
Can I bring this?
Yes, please.
So this was the original.
Okay.
Do you have a copy of the other notices?
If requested, I think by the magistrate, who may provide them.
And Your Honor, during that time.
Just
Okay.
a moment. Thank you. I'm a slow reader.
Okay.
So, before I talk about this one, I believe I heard that there were additional notices provided after October 3rd, but before the March 5th.
Yes, there were. And then also no permit was obtained either for this repair on this sign. So the
I'll call that stabilization.
yes. So
Um,
the additional notices will include what's
so what other notices were sent?
he
I'm
has a
sorry.
copy of them.
You have to produce the notice because we're not
No
aware of
problem.
any notices that
Okay.
came before the hearing. I don't have it. I'm sorry. I don't think there were any.
Okay, Your Honor, I can go get a copy of the notices. Christian will.
I actually, I'm sorry, I take it back. I think it was notice about garbage and cleaning the property, in which we did comply.
Okay. In this picture, Mr. Melios, is that the final, that was done? The work was completed
The
in this photo?
If I may provide a picture to Your Honor, which was taken a couple of days ago.
Well, no, I was referring to the October 29th photograph. I'll,
We
I'll,
needed to comply with the cleaning up and everything, and this is the final. I don't remember exactly when those were taken, but around the time of compliance, because we immediately went, as you see, on the 29th, it was done.
so let me just ask, so these yellow bars, are those the same yellow bars in that picture? Okay. I'll return those. If you'll let Christian take a look at those.
Sure. Same thing. I need to get it back in business. We need to go there.
These were also.
While she is getting the other notices, did you guys change ownership? Because I see this letter was sent to Corinthian LLC team,
Yes, yes.
and now you've changed it over to.
Des
To
Luna
this note,
LLC, yes.
Okay.
and maybe
And
notices can be, I guess.
transferred, yes, because the only notice that Des Luna received was the notice of hearing, no previous violations, but I don't know if that's just the process.
Well, this was sent to your Broward Road address, and I
Right.
think is that where
Yeah.
you reside now, or
Yes,
did?
my brother was the owner, the previous owner, and that's how I found out that there was even a violation.
Oh, Corinthian was your brother.
Yes.
Okay. Christian, have you seen this letter? I just wanted.
Not in a long time.
Thank you.
Your Honor, can I provide you with that?
Just a moment, please.
Okay.
Okay.
No, you just told me.
No, I don't have any.
Okay.
I have the first one, last one.
Okay. Oh, she came back and then she left. Okay.
If she doesn't come back, the hearing is concluded, right?
She'll be back.
The final that was sent on the 5th, that's the one section of the book. But it's the final one that you sent. October 31st.
Oh, so it's in between this and the last one here.
Yeah. Yeah. Oh, I think this one was when the police department, yeah, the police department had contacted us about the trash and debris.
I'm ready whenever you are.
Oh, okay. I thought you were still writing. So 2 additional notices were actually 3. There was one sent on October 3rd,
Oh, is it a different one?
I'm sorry, the one on October 31st was sent in regards to the sign being non-conforming. I have a copy of this. February 5th, she's going to bring me the copy of that one, which was the final notice.
Okay, let me. So in the October 31st, you stated that the violation,
Of the non-conforming sign. And it was all the reasons under section 34,450 was listed, but the main one was that the sign was discontinued.
right, discontinued for 180 days.
Yes.
So again, that language is, sign structures that remain vacant, unoccupied, or devoid of any message, or display a message pertaining to a time, event, or purpose that no longer applies for a period of 180 days shall be deemed to be discontinued. And if it's deemed discontinued, it has, it's the responsibility of the property owner to remove the discontinued sign.
Correct.
Okay, I want to ask Mr. Malios if this was sent to Corinthian also at Broward Road.
May I ask how was this sent to Corinthian? Because Corinthian is no longer the owner. And I don't know.
Well,
It was
that was dated October 31st.
Yeah, how was it sent? It was sent regular mail, certified, or because I don't believe I saw this.
another
violation.
that notice was sent regular mail, and on February 5th, a final notice was also sent
How
to the same address,
regular
regular
mail.
mail.
Okay.
The same
Was the
address that we
property
have for the notice of hearing.
Is that the only one for October 31st? It wasn't posted or anything else. Is that correct?
No, the only thing that is ever posted at the property is the notice of hearing.
Okay, so this was just a notice of violation.
Yes, ma'am.
If I also may say, Your Honor, this is coming up now in this hearing, and of course what it was posted on
Okay.
the
May I-
property.
Okay, may I see the
but,
October
but
31st?
the initial, although this first initial violation, notice, whatever, it wasn't threatening at all to us. We complied immediately. It never mentions anything about non-compliance or,
That's another notice, but
yeah, it did mention nuisance violation,
she has the
debris,
October 3rd.
and all that.
Yeah.
And you have the October.
Yeah, could I see the October 31st one back, please? Did you or your brother, to your knowledge, did you receive this October 31st
No, I
letter?
don't believe I've seen this. I would have acted because I always communicated with the officer, and I have to say, in the past, she did speak to us once, I believe, and we cleared up some nuisance violations that we had. But
So you didn't receive it,
this,
but this business is your brother's, right?
right,
Corinthian?
but it's no longer, yeah.
Okay. So we don't really know whether he got it or not.
I don't.
Basically, we don't know for sure about the October 31st. Okay. And then you said,
Then there was another one on February 5th that was sent.
okay, and where's that one?
We cannot get that one to print, but the clerk is going to bring it as soon as something's going on with our printer.
Of course.
Yes,
It always happens when you
right
need
when
it,
you need it.
you can't get it.
But there was a final notice of the same about the non-conforming sign.
Okay, while we're waiting for the February 5th, I have a question about the October 3rd.
Okay.
Because you said you did get this one,
I
the
did,
October 3rd.
yes.
Okay. Nikki,
Yes.
this sign, this letter was also sent, it appears, regular mail. It was sent to Corinthian. It said that there was an inspection done and that the property's in violation of 34-445, which is signs declared a nuisance and repair. That provision says that the building official may order the repair of signs declared a nuisance, and with or without notice may cause any structurally unsafe or structurally insecure sign to be immediately removed if the sign presents an immediate peril to the public health or safety. Did the building official declare this sign a nuisance?
Yes. So originally, when that notice was sent out, I was informed of the leaning sign by the building official, and so that's when that letter was sent out. After speaking with the planning director and with Christian, and was informed about the non-conforming sign, that's when the second notice in regard to the non-conforming sign was sent out. So that was initially
Right.
from because it was unsafe, because it was falling.
What did the building official, or do you have something in writing where he declared it to be a nuisance?
No, he just told me verbally that the sign. I don't
But
recall
this
if I
letter-
received the email. I don't.
This letter doesn't say that. This letter only,
I was informed by him.
We were not.
You were informed by the letter, and based
no,
on
what
the-
I'm saying is that the letter itself doesn't actually say that the sign has been declared a nuisance.
it.
And it
I want to
also
say up in there
doesn't,
if it's under unsafe.
it doesn't say that either.
Okay,
It's
I don't
just a
know
reference.
verbatim what it states.
Well, you can, I mean, it just cites the section, but there's no,
That's why we took immediate action.
it just says what the code says.
Okay, but then, like I said, again, once the sign came into question, I was then informed by the planning director and the zoning department that the sign was also a non-conforming sign.
I'm sorry. What date were you informed, ma'am?
Kristen, you sent me an email.
Yep. I mean, I can look at the time, but I mean,
Yeah.
the sign's been non-conforming for years, and it's been vacant for years as well.
And so on here it says signs presenting immediate peril to public health
Ma'am,
and
I asked
safety.
a question. What
I'm
date?
sorry, let me,
Yeah.
I'm responding to the magistrate right now. Your Honor, it does state on here that signs presenting immediate peril to public health or safety. So that was the that was part of this notice in regards to the sign falling.
No, that's not what the letter says, but that I disagree.
No, it's right here.
I know what
Okay.
it quotes the code.
Uh-huh.
It doesn't say that the sign has been declared a nuisance. It doesn't say that the sign has been declared a unsafe. And there's nothing.
It says
it's the building.
dilapidated.
It says that the what?
It lists on here dilapidated sign. Right here that's highlighted. So the
that's in the-
verbiage doesn't say unsafe,
It-
but it falls up under
No,
34,445.
no. That provision requires the building official to declare the sign a nuisance or determine that it's unsafe.
So
And
you're
the-
saying
and the
this
letter-
this letter should have came from
The letter doesn't
Bill-
say that, and there's nothing in writing from the building official that the building official ever did that.
Okay, the building official normally just refers any cases that need to be made to code enforcement.
If he wants to declare something a nuisance, or
Mhm.
he wants to use that provision, he actually has to declare it a nuisance in writing. You can't just verbally tell somebody, "Oh, I think it's a nuisance." It has to be. You can't just do that to a property owner. You have to, if you want to use that provision,
And it's visibly showing that.
and he should have declared it a nuisance. He doesn't just, and the letter, if nothing else, the letter should have said, the building official has declared it to be a nuisance or unsafe. So in my opinion, that October 3rd letter, quite frankly, makes it sound like you need to fix the sign.
That's what
Okay,
it
We
is.
so again, if the building official is my immediate supervisor, if he informs me that there is a violation, he relays that information to me as code enforcement, that there's a violation, then I issue the violation notice that is coming directly from the building official.
I agree. However, your letter doesn't say that.
Okay.
Isn't it also a
Can you read
hearsay?
that for me? 'Cause I'm-
So
The building
I'm
I'm
says-
going to ignore. I don't think the October 3rd letter is of gave them notice that the sign. The only thing it did was give them an idea that they needed to fix the sign, which should have been, quite frankly, pretty evident. Okay, I'll be, just being fair. So then this October 31st, they say they didn't get it. Then we have the February 5th.
I have that here.
Okay, good. Let's see what that says.
It's the same.
Okay, so this is identified as final notice.
Yes.
That's because you'd sent this
Yes.
one. But again, it was, so is that standard practice? You don't send certified when there's a notice of violation?
No, we don't.
Just
Only the
regular
notice
mail.
of hearing
And no-
requires us to send certified and post at the property.
Only for the hearing.
Yes.
Also was sent to Corinthian team, which was no longer the owner.
Well, that's possible, but you know what? It takes time for the
Yeah,
public
I
records
know.
to change,
I'm
and
just
all
saying
they
that's
have,
why we
the only thing that they have access to are the public records.
And that's the
So,
same address.
I don't know when
It was in
did
November. Yeah.
when was the sale from Corinthian to Desluna? When did that
in
happen?
November.
November of
In
2024.
November.
Yes.
And was there anything recorded in the public records?
Yes.
And what day was that?
November 26th, 2024.
Okay. And do you have a copy of that recording?
No. But I can produce it on my phone if that's helpful.
Was it a deed? Is that
Yes.
basically what it was? A
Mhm.
deed from Corinthian to Desluna?
Yes.
Okay.
What was it? complete closing.
Yeah,
Which-
general warranty.
It does take time. This was dated
Yes.
February 5th. Wouldn't surprise me
Okay.
that the record still, and that's all the city has to do is look at the records.
Mhm.
They can't know
Right.
that
course.
you've sold it
Of
or
course.
that it's been purchased. So this one clearly, notes that talks about the discontinuance, and it doesn't raise, the nuisance. It doesn't raise the unsafe perspective. So, did you receive the February 5th?
Not to my knowledge. I only have the initial, my brother, that was sent to my brother to Corinthian team, and that's when I acted, and then I forgot about it because she took over, and it changed ownership, and I didn't. Uh, I was actually away in November until when was I? I had surgery and I wasn't here for quite a bit of for almost a month. So I don't recall any other notice except this one that we got it on the
Posted
posted. Yeah.
and not certified mail, just posted.
So, this is a little bit like the Seahorse Florist. We know, or well, let me make sure. Has there been? When was the last time that you know of that there was a business in this building? That it was Hillbilly Wing Shack?
We were there a couple of weeks. We go often.
No.
To man.
When the business was operated inside the building, Hillbilly Wing Shack.
Even as a restaurant, so it's been a year and a half, 2 years maybe. I don't know.
It's also worth noting, Magistrate, that business never finished the process of becoming a legally registered business with the city.
Hillbillies never did.
They were in the process when, I don't know why they left, but they left.
Yeah, we were not aware. We didn't have anything to do with the operation of the restaurant. We own the building only. We don't. We actually, they own. Hilly Billy's went there illegally without our permission. They got permission from the person who was holding the lease, and we had to evict them. And they filed bankruptcy, and it took forever to evict them. And it
Okay,
got,
but you do you both live at 2822 Broward Road?
I live at 2843 Broward Road,
Next door or
across
close
the
by?
street. Yeah.
Okay, but your address was 2822.
yes.
Okay. You also said that you've been trying to market the property.
We've been.
Do you have a current, what's that called?
Perspective?
No, a current contract with an agent for marketing it? What,
Yes.
a rental? Do you have
Yes.
a rental?
Yes.
A broker or
Yes.
somebody?
Yes.
Who is that?
My son is a broker, and we have a. Last week we got an LOI, which we're in negotiations of.
An LOI for it?
Yeah, for leasing and putting it back in business as a restaurant.
Can you guys tell me what this little sign to the left of the big sign, Hillbilly, there's a little tiny sign there.
It says for rent.
It says for rent?
Right.
And it has a phone
okay.
number?
I couldn't tell you. It's pretty overgrown right there.
Yeah.
Yeah.
Also, snipe signs
Okay.
aren't legal.
I
So,
have another phone needed.
Magistrate, can I just interject something?
Please do.
So it seems like the question at hand is whether they were given notice and the time frame they would have to comply, because there's no argument that the sign has been discontinued. Regardless of whether it was damaged or not, it's been vacant for a long period of time. So I think personally, rather than going around the horn a third time, maybe we can just determine if they need new notice and then when the period of compliance would be, if that works. Because I don't think there's a question that the sign wasn't in use as a commercial sign.
Right. Do you understand that that the fact that the business, there's been no business in there, nothing operating in there, certainly not Hillbilly's Wings Shack. And could you show me the current sign, please?
Yes.
Right.
That's actually not the current site sign.
This was taken today.
Oh,
Oh, okay.
We have photos of the front if that helps as
But
well.
can you, there's no,
There's no message or anything.
that's what I was going to ask you. Is there any message on the sign?
no, I provided you the picture, Your Honor. That
It doesn't really matter. It's been discontinued. So,
I do have a question though.
Okay.
Number 2 on the hearing notice. It says, except as provided in this section, a non-conforming sign may continue in the manner and to the extent that it is existed at the time of the adoption, amendment, or annexation of the division that render the sign not non-conforming. This section shall not prohibit the reasonable repairs and alterations to non-conforming signs. So it is the only, basically, paragraph that is not highlighted, and I don't know why we're not using that, because it does say.
the reason that you're not using it is because of the second page under number 4. And it talks about when signs have been discontinued. And the business that you had was discontinued, or that was operating there, has been discontinued for more than 180 days. That's an automatic. When that happens, the sign becomes illegal non-conforming use. And when it becomes that illegal non-conforming use, that's when the mandate to remove that sign is triggered.
And D also mentions a sign permit, which was not obtained.
So I think we're at,
See where it says.
I have to go by what the code says. The code says that if it's discontinued for more than 180 days, then, and this is what is referred to in the notice of violation, then if it's discontinued for more than 180 days, then the sign needs to come down. So I understand that, that it's possibly a hardship, but the code requires that. It doesn't mean that your new renter or your new buyer, if you have a LOI, they can put up a new sign. You heard earlier them talking about a monument sign for the Duncan, but your situation is very different from Duncan. And I'm only bringing this up so that you understand that and the difference. Duncan is still there operating. Their sign talks about a Duncan special, something that they're selling inside that store. In this instance, it's more like the Seahorse Florist that's been out of business. There's been no business in there for a couple of years. So for consistency on my part, I think that it's only fair that I find that the sign is a illegal non-conforming use based upon the discontinuance, and that it needs to be removed.
The Seahorse Florist, if I understood well, is a residential property now. It's not a commercial property.
That part really wasn't so important. The part that I ruled on was the fact that the Seahorse Florist hadn't been there for 4 years, and no other business had been there for 4 years. In our case, we know that there's been no business in there for anywhere from a year and a half to a couple years, you said. So the only thing left in my mind to ask you and the city is the time for removal. And I would entertain suggestions from the city and from you regarding an appropriate time frame for the sign to be removed.
Your Honor, being that this case has been ongoing since October, the city recommends, I would say, the max 60 days.
Well, I have real concerns about the October letter.
Not the October 3rd, the October 31st is when they received the first notice of the non-conforming sign, October 31st.
Right, I know. So what would be, so the city has said 60 days. That's consistent with what they said with the Seahorse case. What is your opinion? What would be a reasonable time?
We didn't get October 31st letter.
I know. All right. I know that you've testified to that. Yes.
Yeah. The sign is clearly in the property. It's property line. It's inside the property line.
Yes.
It's not on the sidewalk. It's nowhere near any city property. I don't know if I should consult a lawyer to have a hearing or do something, another hearing, or I don't know what the legal process could be here, what my rights are basically.
Because well, based upon, I will tell you that you do have the right to appeal my decision to the circuit court if you want to. You could talk to a lawyer about that, of course. But I'm going to rule, and I'll issue an order sometime in the next week or so. The only question that I haven't answered or haven't determined, is a better word, is the number of days that you would like to have, that you think is a reasonable number of days for you to be able to undertake the removal of the sign. And Nikki, does the removal also require a permit?
No.
No, it does not. Okay.
If I may ask, moving forward, if now is the opportunity to ask the code enforcement, there is no way that you can preserve those signs, even if you opened up a business and you apply and you renovate, and we intend to do that. We're because not abandon the property,
Because it's a non-conforming sign and the city does not allow those. They have prohibited those. So once it falls under any of those provisions, then it becomes an illegal sign.
So if we let's say we come and we say open another restaurant and we apply for a permit and we renovate, and we could not preserve that sign and fix it and get permits and all that. No. Lights or nothing.
No, sir.
Okay, I did not know that. Okay. I thought that we could.
Yeah.
Now
make it safe and buy time and fix it, and we are going to do that. But the finances are not there right now.
You can come in and ask for a sign that does conform to the building, to the sign code.
No, he was saying conform.
But not this sign.
Not this sign. That's what I wasn't clear about.
The person that you're negotiating with right now, they can get us a new sign, but it's going to be
a monument sign, as I understood. Yeah, I did not know that, and that's something.
So what? Going back to the number of days. We're
going to go back to Seahorse 120 days and call it a day. That's what I would say.
Well, let's see what.
We'll comply.
I think we should just stick with. I'll do the same thing I did with Seahorse, which is the 120 days, and that will be July 23rd. No fines at this point. You have until July 23rd to correct it, to remove the sign, and if you don't remove it by then, this item will come back. Well, it will come back to me anyway for that it's been determined to be in compliance now if you remove it. and no fines. If it's not removed by then I will issue $250 day
Yes.
fine. So
We don't have to come back on July 23rd if we remove it, right? We don't.
Correct. It's up to you. You'll get a notice of hearing,
Right.
notifying you of the hearing on July 23rd. But if it comes into compliance, if you get it done before July 23rd, if you would just notify me so that I can close the case.
Close. Yeah, very fine.
What would
Okay.
be the best way to notify you?
Email.
Email.
Mhm.
Okay.
Is that
And then you should have my email address because we've spoken.
Yes,
through email.
we have.
Okay.
I think we do.
I
Yeah.
think it's code enforcement at something.
Yes.
I
it's
wish you
code
luck
enforcement.
with the sale. Good luck with the sale. They
Thank
can
you.
do something wonderful. Put in a nice
Yes.
new monument sign,
Yes.
and people will come and be very excited about
The
a
sign.
new restaurant.
The sign is a minor detail of what it takes to
I
put this
know.
back together.
I, be-
This
I,
way.
I definitely believe
Yeah,
that. So
it's,
thank you very much for
and
being
we're
here
trying
today.
to maintain as best as we can, as Ms.
Okay.
Beavers knows. I mean,
We've got good people over here to work
it's
with.
a
They're-
war zone there with the homeless. It's unbelievable how much.
Thank
know,
you.
right?
Yeah, and that's off the record.
Yeah.
But we need to keep that maintained too, as far as because we're getting reports from the police department
Yeah.
in regards to that. So you guys can.
I think the most recent one we did clean up. I don't know if you've been there.
Yeah, I
since.
did. I went to that.
Yeah. Oh, you have the side of the building, if I may say, and I don't want to hold the court, but that driveway between the tire shop, the dumping now. It's
Yeah,
in
we
it.
have to put a fence. So we'll
The
talk.
building
If you
is-
email me, and we'll talk about some suggestions.
The building is the fence.
Okay.
That's our property line, the building. There's no property that we have.
Oh, okay. Gotcha.
It's a city property. Between the two properties, it's a city-owned property. They're putting now
Yes.
sewer or something. So they told us.
Okay.
We said we're not gonna claim what is not ours because they done from the
Yeah.
tire place. They back it as they done.
Okay. So we'll talk. And get some
Making sure.
Yeah.
Make sure.
Do you have a phone number?
Yes.
Okay. Let me put it. Yeah, email is the best because I'm out in the field. Okay.
Answer, I call like 3 o'clock in the morning, 4 I go.
What's your number?
To we'll call here because sometimes I'm working on machines.
And your name? Okay. We'll talk about the nuisance part.
Is it your cell number, the office number? What is it?
It's both, but I was out last week. I was away at the conference. So we'll talk. Email me. Okay.
But with nothing more pending now other than that garbage that was in there, and the city people said we're gonna clean it. This is our problem.
Yeah.
Do you have anything? Did you see?
I can't recall it right now, but I got one more case I need to finish. Okay. All right.
Thank you.
I'll talk to you about it. Okay. Thank you.
Thank you, Your Honor. Have a good day.
Thank you very much.
Okay, Your Honor, our last case on the agenda is case, item E, case number 23-130. And this is, property owner 1121 North 3rd Street Incorporated, violation address 1121 North 3rd Street, Jacksonville Beach. It's in regards to, outdoor display. We were here, and during the last order, Your Honor, you stated that if the property owner did not remain in compliance, that there would be a fine. And on February 14th, the property was observed having merchandise out for sale. Again, as you can see, these are the tags showing the price of the items, that were listed, that were set outside the property of the business. So the city is recommending that a fine be issued for the February 14th violation. Now, in response also to that, since this date, the ordinance has changed. That will, as of the 17th, the ordinance changed.
The new land
The
development code?
new
Yes, it was
land
passed on
development
Monday the 17th.
that
Okay, do you
now,
have let me just stop you, because do you have a copy of the new ordinance that I can look at?
the land development
I have a scribbled on one you can look at.
So that was February 14th.
prior to, yes,
And then what day was this
March
new?
17th.
March 17th.
I think so we're under the commercial district, and then under permitted uses, it has that right there.
Okay. So it's commercial limited, just for clarity,
Yes.
for the record. And this was adopted on March 17th.
Yeah, that's not a complete current copy, but
That's
the
okay.
language is the same, yeah. It's also available online on the city's website.
Okay, so number 7, outdoor display of retail merchandise is limited to bicycles, plants, and outdoor furniture, limited to 200 square feet in area, and only during a business's operating hours. Is that right?
Yes.
Okay. So this was new language was adopted and made effective March 17th.
Yes.
Okay. And I know that these pictures were taken February 14th, so presumably before the new subparagraph 7 was adopted. Was it pending at the time? Do you know?
What was the date of the?
February
February
14th.
14th.
No, the first reading was in March.
Okay. So that would have been presumably March 3rd.
That
And
sounds
then
right.
14 days later.
Yeah, we had a final workshop on February 22nd.
What day?
22nd, we had a workshop with council and the public prior to the first
March 22nd?
reading. February.
Oh, February 22nd.
Yeah, it was like an informative workshop before we completed the code and took it to council.
But technically not pending.
Correct.
And that was a workshop between the commission and,
It was with council and the public. It was an opportunity for
Okay.
public input on the final draft.
I'm going to put this over here just for the moment, okay? So the outdoor display is now, with those limitations, is now a permitted use.
Correct.
If it's outdoor furniture. And on here you can see,
Yeah, outdoor display of retail merchandise is limited to bicycles, plants, outdoor furniture, limited to 200 square feet in area and only during a business. Those are in the list of under 617B, which are the permitted uses.
yes.
Okay.
And some of these items include a wine rack.
And what's the picture on the left?
I want on the left,
Yeah.
this one, the wine rack and a bench.
I'm sorry, what is it?
Let me see what it states on it. So, oh, you're saying this one over here? That's part of the. It says a teak bench, so
It's a
that's
bench. Okay, that teak bench. And then what are you said that those are both of those items
wine racks,
wine racks? And what are they made of?
wood.
Some kind of wood. Okay. And so you posted this on February 14th. And
It was observed on February 14th, and then a notice was sent to the
And-
property owner and hand delivered to the employee that was
Right.
working.
to T. Gregory. It was
Yes.
posted and then certified mail to
It
T.
was sent certified mail and hand delivered.
Right.
Mm.
And then also certified mail to the property owner.
Yes, correct.
Okay. One other question. Have you observed any other time before?
No, no other days were observed prior to the 14th.
Okay.
I also today went by there and did not observe any violations.
So just the one day that is
That
your
was the day I
testimony
observed. Yes,
that
I was
particular.
actually in the area and observed it.
Okay. And this is today,
Yes,
and there's nothing outside.
correct.
Okay. Do you have a recommendation at this point, or do you want to hear from
My recommendation would be to the fine that was stated in the previous order,
to do what?
for the fine to be issued that was stated in the previous order if they failed to come into compliance. Well, if they repeated the
And what would
violation.
that be for one day?
Hmm.
Okay. Please come up and thank you for your patience.
Sure. Good afternoon, Your Honor. My name is Panton Poe. I am an owner of Pink Moon Imports LLC, which is doing business as T. Gregory Imports at the subject location. Swear me in.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth so help you God?
I do.
Please state your name and address.
My name is Panton Patrick Poe, and I am an owner of the business that operates at 1121 3rd Street, Jacksonville Beach, Florida, as T. Gregory Imports.
I have a question. Are you also here on behalf of the landowner?
No, I am not. But I would like to move for a continuance. And the reason I would like to move for a continuance is because the legal issues presented are currently on appeal. As Your Honor may recall, we had a hearing on September 25, 2024. After that, an order was entered on October 8th, and an appeal was filed in November. That appeal is still pending. I'm in communication with the appeals counsel for the city, and that appeal is moving forward. It is still open. We're awaiting the appeals responsive brief. I imagine will be filed soon, and we hope that the legal issue will be resolved. And at the end of the day, as you may recall, we fundamentally have a disagreement about the law as applicable. And so we appealed it. And so I'm not trying to address the merits here today. I'm asking for a continuance because if the appeal goes one way, then this issue will be resolved in exactly the same fashion. And if the appeal goes the other way, then I suppose we'll come back here and address the issue in accordance with the appeals court's determination. And so I would I would move for continuance and to hold this in abeyance until we get a decision and direction from the appeals court.
Okay, do you have a response to that?
My response would be to follow through with the city's recommendation.
Okay, I'm going to, find that there's no violation based on the fact that the city has changed the code. The one day for, which is all we've got, and I wouldn't be able to fine you for anything more than that. And that's all the evidence that we have for $250. It's, in my opinion, given the new code provision, I don't believe that 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 in my opinion, I'm not going to find that there was, even if I find that there's a violation, I'm going to, I would say that there's no fine, but my preference for my order, and I know that I'm talking around it, but my, I believe that the appropriate order today, based upon the new provision that's in the code, is quite frankly moot, in my opinion. And I would, I don't believe that there's reason in light of the new provision in the code. I'm not going to fine Mr. Poe and the business $250 for the one day of evidence that's before us.
Can I say one thing? Based off of what the new code states, that it be strictly followed, not extra items such as wine holders and, if it's not outdoor furniture, because I feel like the business, you give them an inch, they take a yard, and test what the ordinance states, that it should be strictly followed by, because the ordinance was changed to allow the outdoor furniture, but not to, okay, let me put a little outdoor furniture and let me add a couple other extra things. And then we'll be back here again for another year going back and forth.
And I would say that it would behoove the city to try to define outdoor furniture, because I can easily see myself having a wine rack on my porch, which is outdoors. So I you know, I don't think that the wooden wine racks are strictly allowed or could only be used indoors. I can easily see that that could be outdoor furniture. So, I think that that is the right decision on my part. And I understand, but that's all we've, if there'd been violations ongoing from all the way that we had evidence before us today, that this has been going on since September and all the way through March 17th or maybe March 3rd, I would feel differently. I would feel that it was, you know, basically, a blatant disregard for what the code says.
Because
But,
to me, that's just like saying, okay, you're getting a speeding ticket. You're not going to get one this time because even though you broke the law, I'm not going to give you a ticket this time because it's only one time. But
Well,
then
that's
somebody will keep on doing it because they felt like they got away with not getting fined or got a citation for that one time that they, broke what, the law
I
was.
I I I understand, and I think that's a good example.
Hmm.
But we have a very, in this case, the state to go along with they changed the speeding limit, and I know that they're changing the speeding limit, and I'm here after they've changed the speeding limit, and he was 5 miles over the speeding limit. I think it doesn't it's because I do have some discretion, not a lot.
Hmm.
I have some discretion, and in my opinion, there's not enough evidence to say that what he had there was um, on February 14th was in fact would violate the March 17th provision. In my opinion, it doesn't. So,
But even though the March 17th had not been approved, he was still in violation on that day.
I understand.
Hmm.
Um,
And that will trigger all other businesses to do the same. If they see one person do it, the first thing they say to me on a regular basis, well, so and so did it, and so did it, and so it's a domino effect. And so I have to, again, try to stay consistent because when another business saw that furniture,
yes,
they felt like, okay, well, why are they able to do it, but I was told I couldn't do it.
and you are exactly right, and you did the right thing.
Hmm.
It's now in front of me,
Hmm.
and that's my decision. And I understand why you did it, and you did like I said, you did the right thing, and you can tell every person that comes up to you that you did. Um, I think if you point to the very specific facts of this particular hearing and the evidence that we had, and the determination by the city, of 4 weeks later, and not even that, 2 weeks later, March 3rd, they're already hearing it the first time. If you have those specific things, then maybe I'd rule again the way I'm ruling now. But that was I would not expect that to occur very often. In fact, I would say it's less than a 5% chance of that.
Of other businesses doing it?
No, no, no.
Oh, okay.
Of the
Oh,
circumstances,
the
the facts
circumstances
surrounding
where,
this particular
gotcha.
hearing.
Okay.
So when somebody says, well, that special magistrate let him get away with it, well, if they want to come to me with the same set of facts that we have here, then maybe I might end up ruling the same way.
Hmm.
But I don't think it's going to happen very often. And so I'm not, by ruling this way, it has nothing, it's not saying anything um, that takes away from what you have done. You've done exactly what you were supposed to do,
Hmm.
and that's your role. And and I guess I can say this on the record. I have been a code enforcement officer. I know that the struggles that happen, the pushback and the whole 9 yards. So you I don't want you to walk away from this at all feeling like you didn't, um, that somehow I didn't hear you or, or believe that what you did was correct.
Hmm.
It's just under this particular set of circumstances, I believe that the more prudent decision on my part is to uh, uh, basically dismiss the action. So, um, Mr. Poe, you want to say something?
I'll be very brief, and I appreciate your take on the circumstances. It sounds like you're saying that it's made moot by the change of the law and that you're going to dismiss the case. The reason for my motion to continue was to avoid, if there was a finding of another violation, the necessity of another appeal and the duplicity and expense that would go along with that. So I wanted to avoid, at least at this time, the finding of a violation. If your determination is to dismiss it on mootness, then I appreciate your approach on that, Your Honor, and I think that'll keep it efficient, and we'll see what happens with the Court of Appeals on the matter that's pending. And I also do want to say, our goal all along, and I've said this before, has been to comply with the code. And our goal with the new change of code it will continue to be to comply with the code. And so I just wanted to be clear.
That is a good point. It is, if there, there's a limit to what anybody would reasonably think is outdoor furniture.
Thank you.
And so that is something that I think that is going to be important for you to consider. So I don't have anything or more on that. Do you have any questions, Mr. Poe, about I'm going to issue an order in the next week or so, and we'll go from there.
My understanding is the order will be dismissing the citation.
Okay. I don't have anything else. Thank you very much for being here.
That concludes all the cases for today.
Okay.
Yeah.
Did you have any questions, Christian or Nikki, for me?
No, I'm good.
Okay, thank you. And that's it for today.